actually, I am coming back one more time this year. You guys are really special this year, right? But, because, thanks to Albert, yeah. Because you know the purchase contract you all use? You know, every 5 years, there's a forms committee takes a fresh look at it, and they change it. So it usually doesn't change at all for 5 years, but then every 5 years there's a somewhat significant change. And that's going to be, so I'm going to teach a class here. I wish I knew the day, I forget, but anyway, I'm on the schedule to teach a class. You should all come to that class. Today I will tell you some of the things. Today I'll tell you some of the changes, okay? But the class, the form's not even finalized yet. It won't be finalized until July. And it will come out at the end of November. Anyway, so how many of you... Yeah.
September 19th.
September 19th, write that down. You gotta come here. It's not free either, is it? I don't get any money, but it's not free. C.A.R. gets money. Anyway, how many of you were not in the MLS meeting earlier? Not. How many of you were? That's about half and half. Okay. Those of you that were, I apologize, because I'm going to tell the new people the same thing I told you. Not as quite the same way. I'll try to make it a little different. But there's a lot of stuff I haven't told anybody, so I'm going to tell you all that. First thing, yes, for those of you who don't know me, my name is Gov Hutchinson. And there are still realtors, I swear to God, who think I'm the governor of California. Swear to God. Or they think I used to be the governor. So they say, Gov, what was it like being the governor of California? So when was I the governor of California? I don't know, but anyway. None of you thought that, right? You all knew this is just my name, right? So I'm in charge of the legal hotline. You can call the legal hotline Monday through Friday, 9 to 6, Saturday, 10 to 2. You can call as much as you want. We don't limit you. I was telling the group this morning we got more calls now than ever before. I may have to hire more lawyers, but we're all there for you. And all my attorneys, I want them to be nice to you, too. If you ever have a call that's not perfect, call me up. I'm the complaint department. And I will fire them. No, just kidding. I will discipline them. Anyway, you know, I've noticed that the realtors who call first thing in the morning are very serious. And the realtors who call late in the afternoon are usually drinking. It's like, we call them the happy hour callers. That's one of you, right?
Yes, I was one of those that called when I was drinking.
Okay, right.
But I didn't get you.
Okay.
I just want to say, as you mentioned it, that if you didn't get through, if you gave a number, they'll call you back.
Right.
And the first group call back was very, very nice.
Oh, good. Glad to hear that. All right, yeah, so in other words, you can call and wait on hold, or we'll call you back within 24 hours if it's not an emergency, right? And you can call Monday through Friday, 9 to 6. Okay, anyway, so why am I here? I'm here to update you. I want you to know what the new laws are that are important. I want you to know what the new forms, and I want you to know about the new cases. Because there's always something new in real estate. Have you noticed? That's what makes your job interesting, right? It's never the same. Never two escrows are exactly the same, are they? Sometimes you wish they were, right? Just make it simple for once. No, have you noticed it gets harder every year? It definitely gets harder. It gets more complicated, it's harder to close deals, but you're out there doing it. We think the market's going to get better, so hang in there and you'll survive. So first of all, let me talk about some new laws, right? There's a lot of new laws. I'm going to talk about just 3 new laws. Okay, there are only 3 really important new laws this year that you should know about. And they're not really that big of a deal, but they're things you should know. First of all, smoke detectors. Oh. I live in Culver City, and in Culver City we have battery-operated smoke detectors. How many of you have battery-operated smoke detectors? You know how the battery lasts about every 2 years? You know, it starts beeping, right? And then you're a real pain in the butt in the middle of the night that you hear a beeping. What's that sound? Oh, it's a stupid smoke detector, right? You've got to change the battery. Well, guess what? On July 1st, next month, the state fire marshal is only going to approve battery-operated smoke detectors that have a 10-year, non-removable, non-replaceable batteries. So smoke detectors are only going to last 10 years, and they're not going to be beeping every 2 years either. So how are you going to know when it's done after 10 years? You just have to write a note to yourself. Remind me in 10 years to replace the smoke detector, right? But here's the good news, all right. So what if, okay, so you know when you sell your house, you sign the TDS, you certify that the house has proper smoke detectors. So if I sell my house in August or September, do I have to change out the smoke detectors? No. If they still work, you can leave them there. Okay, so what if, when it comes time to sell my house, I realize that the smoke detector in the second bedroom isn't working. I gotta replace it. Do I have to replace it with one of these new ones? No. If I have already got an old one that I haven't used yet. So this is the time to buy up all the cheap old ones. After July 1st, you won't be able to get those anymore. Now, starting July 1st, 2015, a year from now, if you have to put one in, you'll have to put in the new kind. Even if you have the old kind unopened, you can only put in and install the new ones. So this is important for people who sell houses, and it's important for landlords too, because you're going to have to upgrade your smoke alarms after July 1st of next year if they're not working. But if the old one is still working, you don't have to replace it. But once it goes bad, stops working, or you need to put in a new one, the only ones you can put in are these 10-year batteries. Okay? By the way, how many in this room own rental property? A lot of you. Does a landlord have an obligation to periodically check the smoke detectors in your tenant's property?
Every 6 months.
She said every 6 months. First of all, the answer is yes. The next question I was going to say is how often do you have to do it? She said every 6 months. She's just making that up. Because there's no specific law that's a good guideline. At least once a year. 6 months is probably better. But guess what? Once they have the 10-year battery, you don't have to check them anymore. Because the battery's going to last 10 years. There's nothing to check. You can't check it. It's either there or it's either within 10 years or not. You see, some landlords like this because they use it as an excuse to go in. You knock on the tenant's door. What do you want? I need to check the smoke detector. Tenant says, you were just here last week. You say, I'm very diligent, okay? I'm very careful. You're not going to get away with that next year. Yes?
It's a matter of the battery or it's a whole device?
Well, this is sort of the whole thing. I mean, since you can't remove the battery, the whole thing is going to last 10 years, and you're going to have to get rid of it because the whole thing's only going to last 10 years. All right?
I think you're still going to have to check it because things.
You can check and see if it's still within the 10 years. Yeah, if your question is, well, maybe you still have to check it to see if it's still working just because it has a 10-year battery. What if it's not working? I think you're right. I think you can still use that as an excuse. But you know what a smart landlord does? You put in your rental agreement that landlord can make periodic general inspections of the property, so you don't need an excuse. Because sometimes, isn't it true, you don't trust your tenant? And you think they're doing something illegal, so you want to just get in there and see what's going on? But normally you need an excuse. Do you know what the only legitimate reasons to go into a property are? To show it, it's an emergency, to do necessary repairs, or to check the smoke detector. So you want to put in your lease, you want to just come in for any general purposes, that's probably a good idea, right? So everybody with me on the smoke detectors? Yeah.
Question on the smoke
Yeah.
detectors. I have clients who, they put in the smoke detectors.
They can do it, but it's the landlord's responsibility.
Yeah.
You can't delegate that to the tenant. It's ultimately on you, the landlord.
She did speak to the realtor and they told her to do it.
Yeah, I mean, the point is, it's ultimately the landlord's responsibility. And when you sell a house, it's the seller's responsibility. Remember that form called the Smoke Detector Water Heater Statement of Compliance? You know, you don't need that anymore. You know why? Because that's now on the TDS. When the seller signs the transfer disclosure statement, the seller is certifying that the smoke detectors are working and the water heater is properly strapped. But you know that form is still on zip form. You know why? Because what if it's a probate sale or a trust sale or a bankruptcy sale or an REO sale? The seller is exempt from the TDS, but they still need to certify the smoke detectors. So if it's a transaction exempt from the TDS, you still need the smoke detector water heater form. But if it's a regular transaction with a TDS, you don't need the smoke detector form because the TDS now is the smoke detector form. Okay? That's law number one. Law number two, not a big deal, but speaking of the transfer disclosure statement, right? This is the form, every time you list a house, you have a TDS, the seller has to fill it out. Well, they just added a new question a month ago. There's a new question on the TDS. It's the last question. And it's on the last question on page 2 of the TDS. It's question number 16 for the seller. Now, why do you care about that? Because, hey, it's on the seller's section, right? The seller is supposed to fill out the TDS by themselves, right? You don't fill it out for them. So why do you care? Because I think when the seller reads this question, they're going to ask you what it means. Here's what the new question says. It says, seller, yes or no, are you aware of any claims for damages pursuant to section 910 or 914 or claims for breach of warranty pursuant to section 900 affecting this property?
What the hell is that?
Exactly. What the hell does that mean? That's what your seller's going to say. What the hell is section 910 or 914 or 903? That's what I'm about to tell you. What they're asked, those are sections of the civil code that refer to disputes with a builder. So this question is asking the seller, are you trying to get the builder to fix something? Because when you buy a new house, right, if something's not right, you go to the builder and say, you didn't build it right, you got to fix it. And so all this question is saying is, are you involved in a dispute with the builder? By the way, how long does the builder have to fix things? Not forever, 10 years. 10 years. So if this house is older than 10 years old, the question, they're always going to say no, right? It's impossible to have a dispute with a builder after 10 years, because after 10 years, the builder's off the hook. Did anyone in this room ever buy a new house? Brand new? You got 10 years to find out everything that's wrong. If you don't find it in 10 years, you're out of luck. So anyway, it would be nice if this question, why doesn't this question say, are you involved in a dispute with the builder? Why don't we just say that? Because it's not our form. It says C.A.R. and if it's a government form, we just print it for you. So we can't just change it. Everybody with me on this? Everyone understand the new question on the TDS? A question, a home within 10 years old, yes. They're really asking this, so if your seller says, I don't understand what this means, if the house is more than 10 years old, you say, just put no, it's not related to you. Or, if the house is newer than 10 years, say, are you involved in a dispute with the builder? If the seller says no, say, put no. Everyone with me on that? All right. That's 2 new laws. What's the third new law I want you to know about? This has to do with not selling houses, but owning houses, but it's important for all of us to know this. How many of you own a single-family detached house? Most of you, right? All right. How many of you have at least one neighbor? How many of you have a neighbor you don't like? Actually, the real question is, how many of you have a fence between you and the neighbor? Or a wall, right? All right. So let's say your neighbor calls you up one day and says, you know this fence we share? I think we need a new one. In fact, I think we should replace it with a block wall. And I got this great idea. It only costs $40,000, and I want you to pay half. So up until this new law on January 1st, you could have said to the neighbor, drop dead. I don't want a new fence. I'm perfectly happy with the one we got. Leave me alone, go away, jump in a lake. I don't like you anyway. You can't say that anymore. There's a new law that says your neighbor can give you a 30-day notice that says, I think we need a new fence, or we need a renovated fence, or a new wall, and this is my proposal, this is how much it's going to cost, and I want you to pay half. Now what if you just ignore that? They can take you to court and get a court order to make you pay half. So you have to respond. What's your response going to be? Well, I don't think we need it, or maybe we need something but not that expensive. Maybe you can work it out. What if you can't work it out? What if you and the neighbor disagree? They have the right to take you to court And they gotta convince the judge that their idea is a good idea. If it's under $10,000, small claims court. If it's more than $10,000, municipal court, superior court. The good thing is they have the burden of proof to convince the judge that the cost of the improvement will increase the value of each property by roughly the same amount. But if they can prove that, the judge may very well order you to pay half. And you can prove to the judge, well, listen, I currently can't afford it right now. And they'll take that into account. And they'll take into account, is it really necessary, or is it just sort of an aesthetic thing they want to change? So the point is, you can't ignore your neighbor anymore. So maybe it's time to start being nice to your neighbor, okay? Because they may come up with this, yes?
Does that only apply if the fence straddles them?
Exactly. So if this ever happens to you, the first thing you're going to determine is it truly on the boundary? Because what if the fence is 6 inches over on their side? It's their fence, none of your business. If it's 6 inches over on your side, it's your fence, they can't do anything. We're not truly talking about boundary fences. So who likes this new law? Fence contractors, surveyors, appraisers who are going to appraise the house that's worth more now that it's got this fence, and lawyers. Who doesn't like this new law? Everybody else, right? You know how I bet this law got passed? I bet there's some legislator in Sacramento who had a dispute with his neighbor, and he turned it into a law. This happens, by the way. All right, everybody with me on this one? What if there's no fence there at all? Can your neighbors sue you to make you put one in?
Yeah.
No. So if you got a neighbor and you got this crappy little fence there, just tear it down. And the neighbor says, what happened to the fence? You say, what fence? I'm not sure what you're talking about. I'm just kidding, by the way.
I was told that there's two properties, one's
Right.
higher up than the other.
Right.
That bearing wall is
Yeah.
the responsibility of the higher up property.
Not necessarily.
Okay.
How
And
about,
by the way, cities can have ordinances on this too, right?
how about a neighbor's tree leaves always fall on the?
Very good question. That's a good question. Neighbor's tree. Before I answer your question, what if the neighbor's branches come over? You can cut them back.
As long as you
As long as you don't kill the tree. Because you don't know if you're going to kill the tree till you cut the branches. It's like Russian roulette. I hope this doesn't kill the tree when I cut the branches. What if their roots come under? Well, you can't cut the roots. But you can sue the neighbor to make them come in, because they're damaging your property if their roots are lifting up messing you up. They're responsible for that, but you can't take self-help to do it. But her question is, what if the tree is on their side, but every single time the wind blows, the leaves come over on your side? Too bad for you is the bottom line. You gotta rake the leaves, okay? I mean, there's nothing you can do. I'm sorry, but you can't do anything. All right?
compost the leaves.
This is going to be effective, though.
This law I just talked about is already effective since January 1st. Yeah. All right? What's the who?
The number of the statute.
What, are you crazy? You think I memorize this stuff? Actually, I have it here. I'm just kidding. I do not memorize this stuff, but I do have it. It's Assembly Bill 1404. Google AB 1404, and you'll find it.
Are all these bills for life, they go on forever?
That's a good question. Not all laws, but the ones I've mentioned are permanent, yes. Sometimes, you're right, they're bills that are just temporary. These are, the three that I just mentioned are binding forever until they get changed, right? Okay, those are the most important three new laws. Let me talk about forms now. Have you noticed that C.A.R. typically changes the forms twice a year? November and April. But have you ever noticed sometimes C.A.R. changes the forms in the middle of the year? Why would we ever change a form in the middle of the year? It's an emergency. What would be an emergency? Well, maybe they pass a new law that takes effect immediately. Or maybe there's a bunch of lawsuits that are all the same and we need to come up with a new form to stop the lawsuits. Do you know that happened last July? Now listen to this very carefully, because this is a sensitive subject, I know. But first of all, you know there are attorneys who specialize in suing realtors?
Yeah.
I mean, they have meetings just like this. And they have their donuts. And you know what the guest speaker's topic is? New ways to sue realtors. I wish I was kidding, but I'm not. Anyway, so the attorneys who sued you, they tend to have like a mob mentality. If one does a lawsuit and it's successful, they all start suing about the same thing. I remember many years ago it was mold. Remember one year we had all these mold lawsuits, toxic mold? You know, we don't hear about them. You don't hear about that anymore? I never hear about mold lawsuits anymore. How come the attorneys don't sue about mold anymore? Because there was no money in that. They didn't win. But last year, all of a sudden, attorneys figured out there's this new lawsuit that's really effective. And this is lawsuit dealing with pocket listings. All right. What's a pocket listing? That's when you take a listing, but you don't put it on the MLS. You put it in your pocket. You don't offer it to everybody. You just offer it to your own buyers, or maybe your friends' buyers. Now, why would you do that? Because you're greedy. And you want to double end it, don't you? You don't want to share your commission. But is that in the seller's best interest?
No.
Generally, no. It could be. I'm not saying it couldn't be. I mean, some sellers, they want to have a quick sale, they want to have a private sale, convenience. They trust your buyers, they think your buyers are going to be better than anyone else's buyers since they know you already, they trust you, or whatever. I'm not saying a pocket listing is illegal. I'm saying the attorneys figured out it's very easy to convince a jury that when a realtor takes a listing and doesn't expose it to everybody and then double ends it, they were acting in the best interest of the realtor and not the best interest of the client. So, anyway, okay, so here's what attorneys started doing last year. They would call up a seller after they closed escrow and say, hey, congratulations on selling your house. How come it wasn't in the MLS? And the seller would say, realtor never really talked to me about the MLS. What's the MLS? And then the attorney says, maybe you should hire me to sue that realtor who just listed your house. And they would do it. So you know what we did last July? We added a paragraph to the, have you noticed this on the second page of the listing form? There's a new paragraph that basically says what the MLS is. It says this is the MLS, this is what it means, this is the benefits of using the MLS, this is how you opt out of it, this is what you lose when you do that. So this would prevent a seller from suing you and saying, you never told me what the MLS was. So we had to do that to stop those lawsuits. But it didn't stop them completely. There's still sellers out there who are going to sue you if you double end it and you don't put it in the MLS unless you make it very, here's what you have to do. If you're going to not put it in the MLS, you have to look your seller in the eye and convince them it's in their best interest not to put it in the MLS. Maybe it is. Maybe the seller doesn't want it in the MLS. They like the privacy, they like the convenience, they like your buyers, whatever. But you make sure the seller understands what you're doing and they agree with it. Because otherwise you're vulnerable because it's in the mindset of the attorneys now. They're looking for these cases. Okay? So there's a new paragraph on the listing form last July. Everybody with me on that? All right. Were there any forms last November that changed? And this is where, those of you that are already here this morning, I got to say this again. I'll say it quicker than I did this morning. But there was one important new form that came out last November. It's called the Seller Multiple Counteroffer Form. So now you understand, if you get more than one offer and you want to counter more than one, you used to have to check a box on the counteroffer form. Now you give them a whole different form called the Seller Multiple Counteroffer. And as I said this morning, you can only use that form if you're really countering more than one. You can't just get one offer and counter it with a multiple counteroffer because you're lying, you're committing fraud. You have to really only do that. Have you ever submitted an offer though, and you get a multiple counteroffer, and you don't believe the listing agent really has any other offers? You don't trust them, do you? Can you demand that the listing agent prove to you that they have other offers?
Yes.
You can demand it all you want, they don't have to tell you. That's just the way it is. What about this? Can you call up the listing agent and say, and say, $10. She's ignoring us right now. Helen, make her pay the $10. Helen's gonna get the $10 and give it to Mel. Yes, $10. It's going to charity. It's going to a good cause. Yes. Anyway, sorry about that. Now you got one off on a tangent there. Okay. So mobile counteroffers, right? The other question is, could you call up the listing agent and say, do you have any other offers? Do they have to tell you? No. Can they tell you? Yes. Did you know that if they tell you, though, they have to give you a complete answer? They have to tell you how many offers they got, and they have to tell you if any of those offers are their offers. So there's only two possible answers to that question. The first answer is, I'm not going to tell you what other offers I got. You don't have to tell them. But if you want to tell them, you got to tell them how many, and not how much, but how many, and if any of them are yours. Question?
Yes, I'm sorry to backtrack a little.
That's okay.
What happened, the landlord already agreed to the seller to the tenant, and later on the landlord find a realtor, and the tenant also find a realtor. They put the deal together, and now the landlord find out that they undersell his own property.
So it's a sale or a lease?
No lease. There's no lease.
It's a sale.
Just sell the property to
They sell the
tenant.
property to the tenant.
They-
Right. Without
The
telling the
landlord
realtor?
already agreed to sell for this price,
Right,
and everything they
right.
agreed. But they still find outside a realtor, both sides the realtor, and go into escrow. But the seller find out that he undersell his own property.
You found out there are other buyers out there who wanted to pay more? So I think what you're saying is,
Seller with more.
the landlord sold it directly to the tenant. They didn't put it in the MLS. Did they hire a realtor to sell it to the tenant?
Yeah. They hired a realtor to handle all
To handle the transaction. See, I think that's a little different, because that was the landlord's decision. They probably liked the tenant. They probably just wanted to give it to their tenant. Then they have seller's remorse later. Oh, I could have got more money. That's different, I think, than actually taking a listing and then not putting it on the MLS. I think when you sell it to your tenant, you've already got the mindset, yeah, I know, I could put it on the MLS, I'm just, I just want to sell it to my tenant. I like my tenant, I want to give them a first chance. I think it's a little bit different. But that's a good question. If I'm a realtor in that situation, they hire me to do the deal, I'd always say to them, have you thought about putting this in the MLS? You may get more money than the tenant. I mean, maybe you like the tenant, you want to give, that's fine. But just keep in mind, we could put it on the MLS and get even more money. Okay?
In responding to the selling agent's demand for reviewing the number of offers,
Yes.
does the listing agent have to consult the seller still yet?
Yes, good question. Very good question. I should have said that. When the buyer's agent asks the listing agent, do you have any other offers or how many offers you got, you can't tell them until you talk to your seller first. Seller, is it okay to tell them? If the seller says, no, don't tell them anything, then don't tell them anything. You know what I'm saying? So you don't have to tell them, but you can tell them if you want to with the seller's permission. What if the other agent says, oh really, how much is the other offer that you have? Do you have to tell them? No, but you could tell them if your seller wants you to and you think it's a good idea, you can tell them exactly how much it is. Do I need the buyer's permission? No. When the buyer gives you an offer, it's open season on that offer, that you can tell everybody about that offer. Offers are not confidential unless the buyer submits the confidentiality form before they submit the offer and the seller signs it, says, I'll keep your offer confidential. Question?
Doesn't the listing agreement already authorize?
It does. The listing agent, but I would still, it's a good point, the listing contract does authorize you to do that, but I would still go back to the seller, because they may not have noticed that, and they get mad at you. It's better just to remind them. Remember, on the listing contract, you said it's okay, right? That's a good question. It is on the listing contract, but I still think it's a good idea to get their permission anyway. Okay? All right. So that was the So the seller multiple counteroffer form is a new form. That's the only new form that came out last November. Okay? Now, what about last month, right? So we have new forms come out in April. What about April of 2014? Well, there was one new form that came out. And it's not really a big deal because it's a form that consolidated some other forms. Have you ever been a buyer's agent, and the seller is a trust, or the seller is a corporation, or the seller is a partnership, or the seller is an estate? How do you know if the person who's signing is the right person? How do you know it's the trustee? If it's a corporation, how do you know they're the president? If it's an estate, how do you know they're the court-appointed estate representative? Well, we got a form. We have this form called the probate signature addendum. You give it to them and say, sign this, I want you to swear to God you're the estate representative. The trust, okay, here's the trust signature addendum, I want you to swear to God you're the trustee. Corporation, here, sign this form, corporation signature addendum, I want you to swear that you are the president. You know what happened in April? Those forms were combined into one form. It's called, fancy name, Representative Capacity Signature Addendum. Representative Capacity Signature Addendum, RSCA. It just combines all those forms. So if you're ever dealing with a seller, or if you're the seller and the buyer is a corporation, or the buyer is not rarely it's going to be an estate buying a property, but theoretically possible, or the buyer's a trust, right? As a listing agent, give this form to them, make them sign, make them swear to God they are the right person. Because you know if they're not the right person, escrow's going to figure it out, and then the whole deal's going to fall apart. And it's your standard of care to at least make the effort to make them sign something where they swear they are the right person. All right? Everybody with me on that? Representative capacity. That's the only new form. Were there any forms in April that were... Yes?
Does that go for the buyer
Yeah.
also?
Mm-hmm. Your standard of care as a realtor on the other side is to make them sign this form. It's even better to go further than that and say, not only that, I want to see your corporation's minutes that appointed this person the president. Or I want to see your trust document that appoints this person as the trustee. Or I want to see the court order from probate that appoints this person as the estate representative. Your standard of care doesn't require you to go that far, but you have to go to at least the level before that and make them sign this form. All right? That's the only new form. Yes? I don't know. Escrow might ask for it. Escrow officer may actually check and see if they want to see the actual trust document itself. Whatever escrow wants, you know, it's in everyone's interest to do this. All I'm telling you is there's a new form. All right? Now, are there any forms that you already have that were changed in April that you need to know about? I already told you the TDS, right? There's that new question on the second page, question 16, that asks the seller if they're having a dispute with the builder. Are there any other forms I want to tell you about? Yes, one other form.
It's control, WPA.
Don't be jumping ahead. I'll get to that. All right. So for last month, April, right? There's this form. Okay. There's this form called the DLT, Declaration of License and Tax Reporting. Now, this is an old form. It's always been used for one purpose, but now this form is also used for another purpose. This form is part 1 and part 2. Part 1 is in one case, and part 2 is the other. Here's what I'm talking about. First of all of you that have heard me speak before, which is like most of you, every year I remind you that if you're ever representing an investor buying a house that's in foreclosure and the house is owner-occupied, 3 strikes. Strike 1, buyer's an investor. Strike 2, it's in foreclosure. Strike 3, it's owner-occupied. You have to use a special purchase contract, right? It's called the Notice of Default Purchase Agreement, NODPA. All right. There's nothing new there. Now, if you ever look at that form, you know what it says on that form? It says, buyer's agent must also attach with this form another form called DLT, Declaration of License and Taxation. The reason I don't tell you every year, because it's right on the form, it tells you to do it. So in other words, to repeat myself, when you're representing an investor buying a house that's in foreclosure, that's owner occupied, not only do you have to use a special purchase contract, you also have to attach to the contract this other form called the DLT, filled out by the buyer's agent. They fill out section 1. And all they put on that form is what their license number is, which is pretty dumb because you already put your license number on page 8 of the contract. Why do I need to do it again? Because that's what the law says, just do it, right? Quit asking questions, just do it. Okay. But this form also has now another purpose. Listen to this very carefully. You have a listing, right? And you sell your listing to a buyer who is represented by a realtor at a different company, right? So you're not dual agency, it's a different company. Did you know that if you're the listing broker, if the selling broker is not a corporation, the listing broker has to 1099 the buyer's broker for their commission. In other words, you take a listing, you get 5%, right? You put in the MLS, I'll pay you 2.5. You sell the house, and the realtor on the other side is John Smith Realtor. If John is not a corporation, you, the listing broker, have to 1099 John for his 2.5. This doesn't make sense because you didn't cut the check, did you? Escrow cut the check, didn't they? So shouldn't escrow be the one to 1099 him? In a logical world, yes. Do we live in a logical world? No, of course not. So just do it. It's the law.
Because of lawyers, huh?
Probably. Anyway, the point is this. So every single time you sell your listing, you have to ask yourself, is the buyer's agent a corporation? Now, if the buyer's agent is Keller Williams, Coldwell Banker, Remax, you know they're a corporation. Don't even worry about this. But if the buyer's agent is someone you never heard of, or maybe someone you know, but you don't know if they're a corporate, it's just one person, one woman, one man shop, you got to give that person this form. And this form, when you give it to the buyer's agent, section 2 of this form basically asks them 2 questions. The first question, it says, are you a corporation? And if they check the box, yes I am, they give it back to you, you're done, you don't have to do anything. But if the selling broker you give it to is not a corporation, they're going to check the box that says I'm not a corporation. Well, then the next sentence says, well, if you're not a corporation, what's your taxpayer ID number? And they're going to have to sign that and give it back to you, the listing broker. And now that they gave you their taxpayer ID number, you can 1099 them. What if the buyer's agent, John Smith, doesn't want to give you his taxpayer ID number? The law says then you keep the whole commission. So you're going to say to John, if you don't give me that, you don't get paid. John will now give you his taxpayer ID number, right? So everybody with me on this? You got to think about this every listing you have.
But practically speaking.
Yes.
Has the document been changed in escrow? You know how you say you're irrevocably assigned your commission?
Right.
All of a sudden you've got that order in escrow, and yet you've got this form.
So I don't know how escrow's going to react to this. Good question. I think escrow's probably just going to hold the money until it's resolved, because you're right, they've got this irrevocable assignment. I understand what you're saying. But the point is, the law does say that. It does say that if the buyer's agent doesn't respond, then they're not entitled to get paid. So I don't know how it would work out in the real life, but you as listing brokers have to think about this now, okay?
What do you do if the selling agent, they check corporation, but their corporation is expired?
Aha. First of all, remember when I say corporation, I don't mean the agent, I mean the whole company, right? So in other words, the selling broker is not really a corporation anymore. Well, then they're not a corporation anymore. So you can't, you gotta 1099 them. That's what you gotta do. Yeah, so anyway, the form itself, the DLT form, has been updated now so that it's basically like a substitute W-9 form. It serves the function now. You don't need a W-9 form also. All right? Yes?
What happens and how long does that money have to be held then by escrow?
You mean if they're not a corporation?
Yeah, if they don't want to give it to you.
If they don't want to give it to you?
Yeah.
I don't know, it's a good question. So if I was escrow, I'd just keep holding it. If I were the listing broker, I'd get a court order to release it to me. I don't think any selling brokers are gonna not get paid just because of this. They're gonna wanna get paid, I think. So,
Really licensed.
unless they don't have a license at all.
Yeah.
Which, by the way, is a really good idea. Every time you take a listing and sell a house, check and see if they have a license.
Always good.
Because they may not, in which case you definitely keep the whole commission. Right? All right. Okay. Yes?
What happens, some people, they don't have a license, but they demand want the commission.
Don't give it to them. Maybe attorneys do that sometimes, right? Attorneys, I'm the attorney for the buyer. I want the 2.5 commission. You're not allowed to pay them. Unless they also have a broker's license. Attorneys are not exempt from getting a, now a client can hire an attorney to do licensed work, and the client can pay them attorney fees, but they're not entitled to a commission. They're entitled to get hourly rate, attorney fees, but that doesn't give them the right to cooperate on a commission, right? Okay, so that takes care of last July, TDS, yeah.
For 1099 form, will it be issued by the listing agent or by the seller?
Listing broker has to 1099 the selling broker for their share of the commission if the selling broker is not incorporated.
Yeah, so the 1099 form will be given to the receiver or the
Right.
recipient.
Right.
But who is going to issue that 1099? Is that the
Listing broker.
listing broker?
Yeah.
But the money is not paid from the...
I told you, it doesn't make sense. You're trying to be logical here. Don't do that. Don't be logical. It doesn't make sense. All right? Okay. So that takes care. So July, we had a new paragraph on the listing form. Last November, we got the seller multiple counteroffer. Last April, we have change to the TDS, change to the DLT, and the new representative capacity signature addendum. The next time the forms are going to change is November, last week. There's only going to be one change, but it's going to be a big change. The purchase contract is going to have some significant changes. I'm going to be here September 19th if you want to come to the class. There'll be other classes you can go to as well. It'll be finalized. It won't be finalized till July. In fact, you can still make comments yourself. You can go to the C.A.R. website and you can see the current draft of the changes and you can make comments. But let me tell you a couple things that I know are going to change for sure. It's absolutely been decided already. They're not going to change it. The most important change that's going to happen is they're going to get rid of the termite addendum, the wood pest addendum. Now, here's what you normally do now, right? Every deal usually has a termite report, right? And doesn't the seller usually pay for it?
Yes.
Right. So isn't it true now when you write an offer, you come to paragraph 4A and you check the box, seller to provide wood pest report, right? That's not going to say that anymore. If you want the seller to do a termite report, you're going to have to write it in. You're not going to check a box. You're going to have to actually go to the trouble of writing in wood destroying pest inspection report. Then, though, what you normally do now as a buyer's agent is you submit with your offer the wood pest addendum, right? And you fill it out and you write section 1. And don't you usually check the box seller to pay for all section 1 work, right? All right. That form is going away. It's not going to be there. So how do I get the seller, starting in November, how am I going to get the seller to pay for the termite work? Where you're going to use the request for repair form. There's going to be a new paragraph on that form just dealing with termite. But think about it, this is different. You know why this is different? Because normally you don't submit the request for repair form until after you do your inspections, right? You don't submit that with your offer. Whereas the termite form, usually you submit with your offer. You know something? For 29 years, I've been telling realtors, when you get the wood pest addendum form with your offer, don't sign it. Sellers should never agree to do the Section 1 work until they know what the Section 1 work is. So they should, I've been telling you for 29 years, order the termite report before you put the house on the market,
Then you know what.
So if the buyer submits the wood pest addendum asking you to do section 1 work, you know what they're asking for. Or I say, counter the offer and say, yeah, I'll pay $1,000 worth of termite work. Beyond that, I want to wait and see until I get the report. So I think this is what you should have been doing all along. So now I think that's the way it's going to work. You're going to write in your offer, you're going to ask to do the termite report. Then you're going to wait till you get the termite report. If the termite report says section 1 work, you're going to submit a request for repair in escrow to the seller. You're going to say, there's section 1 work, I want you to fix it or I'm not going to buy your house. And then the same thing is, I think that's a better way to do it. And guess what? That's the way they've been doing it in Northern California for the last 50 years. I go up to Northern California once a week. I go all over the place, and they have never used that form. Normally, I favor Southern California. Because I'm from Southern California. But in that one area, I think they've been doing it the right way all this time. I never thought it was a good idea to, as a seller, to commit to do the termite work before I knew what the termite work was. It's like signing a blank check. So, hopefully this is going to be, hopefully you'll all adapt to this and it'll work out not too hard. It's still probably a good idea as a listing agent to do a termite report before you put the house on the market. So then there's no mystery when it happens. Oh my God, there's $50,000 worth of termite work. So this is the most important thing that's going to change on the purchase contract.
All right, so once you order the termite report in the listing,
Right?
you must give that report to the buyer, whether they ask for it or not.
Otherwise, what's the point of doing it? Right? Yes, you do.
You have to.
Because that's a material fact about the property that you're aware of. So yeah. Obviously you're not going to order it unless you assume you're going to give it to the buyer. Why else would you even do it? Do you know there's some places in California where they don't even do termite reports?
Good.
Lenders don't even care. Isn't that crazy?
Where is that?
I was in Lake Tahoe. They don't care. I was in Santa Cruz. They don't really care. Maybe we should all move to Santa Cruz. I'm just kidding. All right, everybody with me on that? Let me tell you one other thing that's changing. In the loan contingency now, it says loan contingency is going to be remain in effect for 17 days. Or there's a line under that, you can check a box and say until funded. The until funded is going away. I know what you're thinking, I always take advantage of the listing agent. I check that box and they never notice it, right? Any rational listing agent is not going to let you get away with that. They don't want to wait 45 days to see if you get loan approval. Any smart listing agents, if you ever check that, they're going to counter you and say, I'm not waiting 45 days to see if it's funded. But the point is, it's not even going to be there to tempt you. And the 17 days is changing to 21. You can always change that. That's just a suggestion. You can change it to whatever you want. All right? I guess she's holding the sign-in sheet, right?
It's a sign-in sheet, yeah.
Anybody not signed yet?
It's the sign, the walk-ins.
All right, so those are the biggest changes for now. Other things are going to change. I think they're going to be adding, maybe the agency form is going to be attached to the contract, so it's right there. There are all sorts of little things. It's worth spending a couple hours at least, or come to my class for 4 hours on September 19th. It's worth it to go over all these changes, because there are going to be a lot of changes. Not big changes, but the paragraphs will be in different orders, things will be rearranged, some words are going to be different. Little things, but important changes. Okay? All right. What else do I want to tell you about? So those are all the forms updates. Those are the 3 most important new laws. Now let me spend about 5 minutes talking about some stuff I talked about this morning. So half of you have already heard this, but it's important stuff. So maybe it doesn't hurt to hear it again, right? If you're doing short sales, the IRS just changed policy. The IRS, last November, they said, if you do a short sale on residential 1 to 4, there's no tax consequence. A month ago, they said, we were just kidding. We really meant to say, there's no tax consequence for primary residences. Or, in other words, let's put it this way. If you're doing a short sale and the loan that's being the short sale was a purchase money loan to buy a house or build a house, there's no tax consequence. In other words, you owe the bank $500,000, the house is only worth $450,000. You do a short sale at $450,000, the bank doesn't get paid the extra $50,000. So the question is, have you received $50,000 worth of debt forgiveness, income? Do you have to report that as $50,000 worth of income? Well, since November, the answer was no. Now they're saying, if you're an investor, you do have to report that income. So if you borrowed the money to buy the house, or you borrowed the money to build the house, and now you're doing a short sale, no tax consequence, even if you've refinanced it since then. So even though it's not a purchase money loan now, it was originally a purchase money loan to buy residential property, you're good. But if you bought the property as an investor, you never lived there, you never intended to live there, it's an investment property, and you're upside down doing a short sale, they're saying you do have to pay income tax on the amount of money that's forgiven, unless you're insolvent. What does insolvent mean? Insolvent means in your overall life, your liabilities exceed your assets. You're upside down, not just in real estate, you're upside down. If you're insolvent, you don't have to pay this income tax. But if you're an investor who is not insolvent or in bankruptcy, you now have a tax consequence on a short sale, just like you used to have. Up until last November, that was true. The only time investors were off the hook was between last November and